Let's talk about how to read those cases in the case packet. Usually the cases in past years have been a mixture of Supreme Court, federal, and state cases, and not in any particular order, whether chronologically or only Supreme Court cases separated to federal cases and then state cases. This year they did separate the cases by type. The first couple of cases are Supreme Court cases, then they have federal cases, and finally state cases. But I believe that they're not in chronological order, and we'll talk a little bit more about why chronological order matters in a little bit. So why do we separate the cases by Supreme Court, federal, and state? Well, the Supreme Court, the United States Supreme Court, is the primary court in all the land, and every other court across America would have to follow that case law that comes out of the Supreme Court. It is called binding authority. Supreme Court cases are binding on all the courts that are beneath them, including all the federal courts. The federal court system is a set of regions across the whole country, with California being in the 9th Circuit. And then Supreme Court cases are also binding on state courts. In California, we do have our own set of courts that are the Superior Court, appellate courts, and the Supreme Court of California. As you could gather from the rule on the Supreme Court of the United States, California Supreme Court cases are binding across California. California appellate court cases are also binding because the trial court that we are in is a superior court, which is beneath the appellate courts and then beneath, again, the Supreme Court. When you're arguing the pretrial motion to the judge, and the judge is looking to you as an attorney to tell them what ruling they should make, it's most beneficial to your side to say, there is a binding case on this, Your Honor, and it's directly on point, and Your Honor must follow that law, which goes my client's way. Or if you're representing the people on the motion, which supports the people's argument. Now, if you read those cases, you'll remember that this year's case is about a ship that docked at port in Portsmouth. This year's case is about two actors who, the defendant is one of them, and the victim, alleged victim, was the other, who had a Shakespearean ring that is alleged to have been stolen by the defendant, and during the stealing process, the defendant is alleged to have pushed the victim down and broken their arm. So robbery and battery. When the detective came to investigate, the detective talked to the defendant in their cabin and asked the defendant for consent to search a safe in that cabin. We'll get into more of the details if we're really going to analyze all that, but what you need to know from that process is, once the defendant is going to trial on charges of the robbery and assault, and the detective is trying to, or has handed over to the people as evidence, something coming out of that safe. It was a piece of paper with some notes on it. And right up front, the detective did not get a search warrant. The defense is bringing the motion to argue that without a warrant, this search was unreasonable. So that's the introduction of what the motion is about. Now let's talk about how we argue the entire pretrial motion, or we talk about any case. The analysis process that lawyers use is called IRAC, Issue, Rule, Analysis, Conclusion. Under the Fourth Amendment, the right is against unreasonable searches by the government. If we had no other cases to look at for the law, that would be our rule. Here, Detective Mavis is representing the government, asked to search, did not obtain a warrant. So the rule against unreasonable searches under the Fourth Amendment, issue, rule, analysis, conclusion. So the overall structure of the pretrial argument is issue, rule, analysis, conclusion. Issue: if the police did not get a warrant, were the defendant's Fourth Amendment rights violated? Rule: the Fourth Amendment provides that our citizens of America are to be free of unreasonable searches and seizures by the government. So if we did not have any case law in that packet, that would be our only rule to apply, and we would start giving perhaps the judge our feelings and our experiences. Part of the lead up to the creation of the Constitution was that British soldiers would just knock on a door or open a door and go on into people's houses and search, or decide that they were going to use that house and stay overnight. And so the Constitution was written that the people of the new nation would be free of unreasonable searches. So if we only went on, are the police knocking on our door and intruding in our house? Well, the investigation was happening, and this detective was invited into the cabin or there with permission from the defendant. And so under solely that test, maybe this was not an unreasonable search. But now when we dig in and look at I think it's approximately 12 cases that are provided in the packet, and we see what the rules are in each of those, we start to see examples of what our Supreme Court and our courts have found to be unreasonable searches. So in the early rounds of pretrial, when we see pretrial attorney students arguing about their motion, what we see a lot is that they talk solely about the facts, and a judge will ask a question, well, what about this one fact? Doesn't that mean that I should rule this one way? And you hear the student talking a lot about the facts. Well, that was one fact, and here were all these other facts, and so given all these facts, Your Honor should rule my client's way. But what is happening when you, as the mock trial pretrial attorney, only talk about facts is you're not giving the judge the rule to measure the conduct against. So the pattern of any answer that a good pretrial attorney is trying to give, in my opinion, is address what the judge has just asked about, a single fact. But then you need to pull from the cases. You need to tell the judge, under the case of, and you name the case. Bumper v. North Carolina is the first one in the packet this year. That's a Supreme Court case. The court held and state the rule. In Bumper, police told a defendant that they already had a search warrant and then asked for consent. And the Bumper court held telling the defendant a lie, that they have a search warrant and so they can search regardless of consent, makes that consent that was obtained by a defendant involuntary, because they've told the defendant that they don't really have a choice. So that would be a first question here. Did the detective tell the defendant that she had a warrant? And now we know from the fact situation she did not, because that would be too easy. Then we would know that the defense would win every time on the pretrial motion just by saying, well, Mavis lied that she had a warrant. And so under Bumper, Supreme Court binding on this court, the defense wins that is an involuntary consent. So instead what happened here was Mavis said that she was going to get a warrant and promised that she had put in the paperwork, arguably. More facts will have to be reviewed. We kind of learn more as the case packet gets digested and we go along, and we're pretty early in pretrial right now. So then we have to start to look to the other cases for what is the rule that we're applying. And usually one of the Supreme Court cases gives you the general test that gets applied to determine voluntariness or whatever the issue is in that packet that year. This year the test comes from Schneckloff v. United States, I believe is the court site. I'll add text over my video in case I got that wrong. And Schneckloff provides that whether a defendant's consent is voluntary depends on all the facts and circumstances. And the Schneckloff court listed off 5 factors that would indicate voluntariness or not. If a judge asks you, what about the fact that your client was of an age that is an adult? Under Schneckloff, those 5 factors are age, level of education, whether a person was given their Miranda rights, length of questioning, and the method of questioning. Those are 5 things that Schneckloff mentioned. It's all facts and circumstances. So if your particular case has an additional one to talk about, why it's voluntary or not voluntary, that you can argue, well, you could add a factor, but that's the Schneckloff test. And so being asked by the judge about one thing, what about the age? The answer would be something like, Your Honor, the age is one of the 5 Schneckloff factors. And then I would say what my client's age was, and that my client is not in the record seen to have had a law degree or trained as a police officer. They were an actor, and so they're not experienced at their constitutional rights. And then I would add in, Your Honor, under Schneckloff, the test is an all facts and circumstances test. And when Your Honor considers, and then I as the defense counsel know that certain of the Schneckloff factors help my case a lot more, then I would go into the 2, 3, 4 things that tended to indicate involuntariness under the Schneckloff factors. But I talked about facts, state what case applies and the rule, and then tell the facts that the judge would look at to apply the test that I just stated was the rule to the facts and come out my client's way.